Okay, the next item of business is consideration of Business Motion 17585 in the name of Jamie Hepburn on behalf of the Parliamentary Bureau on Stage 3 timetable for regulation of legal services Scotland Bill. Any member who wishes to speak to the motion should press the request to speak button, and I call on Jamie Hepburn to move the motion. Minister. I don't think we had Mr Hepburn's microphone there. Could we try one more time? This time with the card.
That was meant to be sleight of hand, Presiding Officer. Moved.
Nothing passes me by, Minister. No member has asked to speak against the motion. Therefore, the question is that motion 17585 be agreed to. Are we all agreed? That is agreed. The next item of business is Stage 3 proceedings for regulation of legal services Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 25A, the marshalled list, the supplement to the marshalled list, and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division at Stage 3. The period of voting for the first division will be 30 seconds. Thereafter, I'll allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate should press the request to speak buttons or press RTS if they're joining us remotely as soon as possible after I call the group. Members should now refer to the marshal list for amendments. And I call group number 1 on regulatory functions, complaints, etc. I call amendment 116 in the name of Paul O'Kane, grouped with amendments 129, 139, 140 and 141. Paul O'Kane to move amendment 116 and speak to all the amendments in the group. Mr O'Kane.
Thank you very much, Presiding Officer, and I move Amendment 116, and I'm pleased to speak to it and my other amendments in the group. And can I set out at the beginning of our proceedings today my thanks to all stakeholders for their engagement and their briefings, indeed in advance of Stage 3 and throughout the bill process, as well as my thanks to the Minister and her team, who have been largely cooperative and responsive to, I think, many of the concerns through what has been a long process within the bill, although I sense we may still end up in some disagreement today, but certainly we'll start off in that positive vein. Turning to the amendments in the group, I will first speak to Amendment 116. Section 7 sets out the meaning of regulatory functions. However, Section 7 does not specifically detail that administering any compensation fund required in terms of Section 14 of the bill will be a regulatory function. The existing fund, which is maintained by the Law Society of Scotland under the Solicitor Scotland Act of 1980, is a crucial consumer protection, and the administration of that fund, the Guarantee Fund, is currently defined as a regulatory function under the existing 1980 Act. Now, I note what the Minister has said to me in writing in advance of this afternoon's proceedings, that she considers that the issue has already been covered within the bill. So I think if she could set out in her remarks if that is indeed the case and how that is the case, and indeed the Government's full position that it is a regulatory function, I think that would be most helpful to myself and I'm sure to colleagues in the Chamber, and I may not then press Amendment 116. Amendments 129, 139, 140 and 141 seek to restrict the conduct complaints being brought against solicitors in relation to them discharging regulatory functions on behalf of regulators as defined in the bill. I think the concerns behind that amendment is that there is an increasing number of often spurious conduct complaints which are brought against solicitors discharging regulatory functions, and that has a real impact on the ability to carry out those regulatory functions and, in my opinion, can be of detriment to the public interest. The time spent dealing with such complaints places a burden on the regulator, and such conduct complaints can drive risk-averse behaviours by those exercising regulatory functions and can also impact on the regulator's ability to recruit and retain solicitor members of regulatory staff. All of that, I think, leads to a slowing down. I'll just finish this sentence and then I will give way. All of that leads to a slowing down and difficulties in completing regulatory processes. I'll give way to Maggie Chapman.
Maggie Chapman.
I thank Paul O'Kane for giving way on that point. I'd be interested in hearing what he has to say in response to the SLCC's position on particularly Amendments 129 and 141. one of their points particularly is that they are uncomfortable in applying standards and processes to others which they would not apply to themselves as well. And I'd just be interested to hear how Paul O'Kane answers that critique of those, particularly those two amendments.
Paul O'Kane.
I'm very grateful to Maggie Chapman for that intervention, and I appreciate that there are competing views in this space and there are competing issues. I think the issue has been perhaps counterbalanced by the view of the Law Society and others in this space in terms of what needs to be done in terms of not placing that onerous burden onto regulators, as I have outlined. But I do recognise what she is saying, and I do take that on board, so I'm keen to hear what the Minister has to say in terms of those issues. Because I do want to be clear that these amendments should not restrict the ability to raise a conduct complaint about other matters which would fall outside the exercise or discharge of regulatory functions. Additionally, solicitors engaged in the delivery of regulatory and disciplinary work for a legal services regulator should not and would not be immune from criticism or accountability. Indeed, parties on either side of a regulatory matter are entitled to express their disagreement with the substance and the manner of arguments that are made by solicitors who work on regulatory matters. Now, once again, and referring to the points I've already made, I note that the Minister has said that she's aware of the issues and she's happy to continue to engage on this matter with the Law Society and with other stakeholders as would be necessary. So I do wonder if, again, she'd be willing to make further commitment on the record today on that, as well as outlining the potential steps that she believes are open to the Government to act on this issue in future, if that is needed, and indeed if an agreed position can be found. So I think if she can provide some of those assurances around further remedies in that area, then I may not be minded to press the amendments, cognizant of Maggie Chapman's point as well. But I do reserve the right to push those, given that I do believe it's an important issue with regards to the well-functioning and the capabilities of regulatory processes and, consequently, our public interest. Thank you very much.
Thank you. I now call the Minister.
Thank you, Presiding Officer. I wish to open by thanking all members and stakeholders for their constructive engagement in respect of this bill. I understand Paul O'Kane has lodged the amendments in this group on behalf of the Law Society of Scotland, and I do consider that Amendment 116 is not necessary, as the bill already provides that the establishment and management of a compensation fund is a regulatory function of the Law Society as a Category 1 regulator. This is because Section 7 of the bill, which provides that of a regulatory function, includes complying with requirements under the bill, is to be read with Section 14 of the bill, which places a requirement of the Law Society to establish and maintain a compensation fund. It is therefore clear from Section 14 of the bill that a Category 1 regulator must establish and maintain a compensation fund, and this requirement is then caught by the definition of regulatory functions in Section 7. If I can move to Amendments 129, 139, 140 and 141 to make provision to restrict conduct complaints being brought against solicitors in relation to them discharging regulatory functions. This matter was raised by the Law Society with the Scottish Government following Stage 2. And while I appreciate and I understand the concerns that was raised, I consider that Amendment 531 that was agreed at Stage 2 will give all relevant professional organisations the flexibility to discontinue a conduct complaint remitted to it if the relevant professional organisation considers it is in the public interest to do so. And this provides a route to address the concerns raised. And I think, as Mr O'Kane has alluded to in his speech in the beginning, there is competing views here, and at this bill, as we know, has a history of trying to find a balance with both sides. So, given that the SLCC briefing has also, sent to members, I will continue to engage with the Law Society to monitor the operation of the new provisions, and I consider this matter would benefit from further consultation and consideration. I therefore ask Mr O'Kane not to press his amendments in this group, and if they are pressed, I would urge members to oppose Mr O'Kane's amendments. Thank you, Presiding Officer.
Thank you. I call on Paul O'Kane to wind up, press or withdraw Amendment 116. Mr O'Kane.
Thank you very much. Deputy Presiding Officer, I think that has been a useful exchange of views in terms of the issues contained in this section of the bill, and I'm grateful to both Maggie Chapman and the Minister for their comments on the record. I think, given the Minister's assurances, I would choose at this stage to withdraw Amendment 116.
Thank you. Paul O'Kane seeks to withdraw Amendment 116. Does any member object? No member objects. Therefore, Amendment 116 is withdrawn. We move to Group 2, Regulation of Legal Businesses. I call Amendment 117, again in the name of Paul O'Kane, grouped with amendments as shown in the grouping. And I call on Paul O'Kane to move Amendment 116 and speak to all the amendments in the grouping. Mr O'Kane.
Thank you very much. I move Amendment 117 in my name, and I want to deal with some of the more minor amendments in the group first, before dealing with the important issue of registered foreign lawyers. Firstly, Amendment 123 would make changes to Section 42 of the bill to allow Category 1 regulators to make rules about the effect of an authorisation of a legal business, which is a partnership or other unincorporated body, where the membership of the legal business changes or another legal business succeeds to the whole or substantially the whole of its business. That deals with an ambiguity in Scots law regarding traditional partnerships to ensure that where there are changes to membership, there is a swift transfer of authorisation of interests of the business. So I'm very grateful to the Minister for her indication that the Government is willing to support that amendment, because I do think it's important in terms of the delivery of justice and support to those who require it when there is such a change as I have outlined. Amendment 126 removes subsection 2A2 from section 44, which currently requires practice rules of authorised legal businesses to have regard to regulatory objectives. Overarching regulatory objectives are applicable to regulators, and it is regulators that must adhere to them. Instead, it is professional principles that legal providers must adhere to, and that is already covered elsewhere in the bill. So I think that that is actually an incorrect reference, which has to be removed from this bill, and I'm grateful again to the Minister for indicating that she is minded to support that amendment as well, which I think will seek to clarify and clear up this bill as proposed, and then subsequently, if it is passed, the legislation. Amendments 124 and 125 remove two subsections from section 44, which require practice rules to include the process for making and handling of complaints. Now, I know that there has been some concern from stakeholders that, given complaints processes are currently set out in statute, that the current provisions in section 44 may not be appropriate or indeed be legally competent. However, I have found the Minister's explanation to me in writing about the necessity of the powers which are provided to the SLCC directing minimum standards is very helpful in that regard to understanding the purpose of the subsections. So as such, if she could again detail that on the record in her contribution, I would be most grateful and subsequently minded not to move those two amendments in particular. Turning finally to the remaining amendments in the group, which are 117, 118, 119, 120, 121, 122 and 138 in my name regarding qualifying individuals and the status of registered foreign lawyers, I do think that this issue is critical to the functioning of the legal services market in Scotland, and this debate was indeed had extensively at stage 2 and heard in stage 1 evidence. My view would be, if we do not get definitions and the status of registered foreign lawyers correct, to provide legal certainty that they are permitted to part-own authorised legal businesses as part of multinational practices, I do think that could have a particularly concerning impact on the legal services market in Scotland, because those ownership structures include some of our largest and most well-known law firms, whose ownership structures could be threatened by implementation and interpretation of the statute in the future. I think it's difficult to understate the level of concern that this has caused within the legal profession, because it is a significant issue that many lawyers feel has been left in the balance for the past 2 years. We're talking about, of course, the ability of some of the largest law firms in the UK to operate here in Scotland, and that is, of course, thousands of jobs and tens of thousands of clients.
Colleague take an intervention?
I'll certainly give way.
Martin Whitfield.
I'm very grateful to Paul O'Kane to take the intervention, and on this point, isn't the reality, although this bill has taken a substantial number of months to get to where we are, if this matter is not resolved, there is a real risk that, if not quite overnight, but in the very short term, we could see the fleeting of the ownership and the control of law firms that exist in Scotland in the minute going to other jurisdictions, which has an incredible risk of a knock-on effect here in Scotland.
Paul O'Kane.
I'm grateful to Martin Whitfield for his intervention, and indeed I think I've outlined and continue to outline in my contribution the concerns that are being raised, and those are many of the concerns that Mr Whitfield outlines. But I think in particular the sense that many well-known and well-established law firms who support people in particular with issues around personal injury, for example, or trade union lawyers, large firms, for example, may have an issue in terms of their operation here in Scotland because of the structures that have not been clarified in terms of the bill. So the Minister at this stage, I think, is well aware of the issues and the potential implications for the legal services market if we don't get this right. They were raised, as I've said, at previous stages of the bill and in correspondence from the Law Society. And I think the Law Society have explained the problem quite neatly, why the bill as drafted should be remedied. They have said, as a result of the provisions of Section 39 in the bill, they stand in conflict with the provisions of the 1980 Act. If registered foreign lawyers are included in the definition of qualifying individual, then at Section 39(2), at the very least that implies that one or more registered foreign lawyers may form a business owned exclusively by registered foreign lawyers without any Scottish solicitor ownership. And that business would require and be capable of authorisation under the bill when that is not in fact correct. Conversely, if registered foreign lawyers are not included in the definition of qualifying individual and no separate provision is made for them, then Section 39 does not permit existing multinational practices to be authorised, which would prejudice the continuation of some of Scotland's largest and most successful law firms, many of which are MNPs. Now, the Minister has indicated previously her intention to alter the explanatory notes on the definition of qualifying individuals in an attempt to tidy up the matter. And I am aware of her correspondence with the Law Society only yesterday, confirming that she intends to adopt their draft text of a revision to the explanatory notes. So I think it would be very helpful to have on the record, and without equivocation, that it indeed is the Minister's intention to adopt the Law Society's text for revisions to the explanatory notes to the Act. However, I do have to say that I am still concerned that such a central issue, which has been the focus of concern since the bill's introduction 2 years ago, that indeed perhaps that letter last night was the first time since stage 2 that the Government have laid out a position directly to the Law Society, who would be responsible for regulating all of these issues, despite them repeatedly raising it. So I have to say that despite that last-minute adjustment to the Government's position, the matter is critical to the legal services market in Scotland, as I have outlined. So I think to ensure that we are beyond doubt and to take what I would call a belt and braces approach, I may press these amendments to put it beyond doubt. So consequently, as it stands, I will be pressing the amendments when they are called, and I would urge colleagues to support them. Thank you very much.
Thank you. I now call on the Minister to speak to Amendment 1 and all the other amendments in the group. Minister.
Thank you, Presiding Officer. And let me start by begin by starting with my own amendment number 1 before moving on to those in the name of Paul O'Kane. The Law Society of Scotland has asked for clarification on the registered foreign lawyers being included in qualifying individuals as defined in Section 39 of the bill. I agreed at stage 2 to correct and strengthen the explanatory notes to bring out that registered foreign lawyers are included as qualifying individuals as they exist at present, but also to make clear that Part 2 of the bill on the regulation of legal businesses does not change on the basis of which existing individual rights to practice are still required by the existing underlying legislation. And this will be done in the explanatory notes to the Act if the Parliament agrees to pass the bill today. And I'll just give my confirmation that last night I have engaged extensively with the Law Society, and I wrote to them last night outlining the position and confirmed that I am happy to adopt the Law Society's suggested wording in the explanatory notes. In particular, registered foreign lawyers will still be required to work with other solicitors in Scotland where there is already provided for in the existing legislation in order to practice, and the new regime in Part 2 of the bill does not change that. My Amendment 1 would define legal business in Section 18 by reference to the definition of legal businesses in Section 39 to make the definition consistent in the bill. This provides additional clarification in the provision about professional indemnity insurance on the face of the bill, similar in effect to Paul O'Kane's Amendment 119, but my Amendment 1 means that Amendment 119 is unnecessary, as defining legal business by reference to the definition of legal business in section 39(2) also draws in the definition of qualifying individual as set out in 39(8) of the bill. While I recognise the intentions behind Paul O'Kane's wider amendments in this group, 117, 118, 119, 120, 121, 122 and 138, which have been developed by the Law Society, we consider that they would have unintended consequences. In particular, they would rule out in some ways using the structures in Part 2 of the bill, which would otherwise cater for these types of lawyers and allow them to be brought in as qualifying individuals. If they were in the future made licensed providers, or if the other rules that govern them changed. On that basis, the amendments are unnecessary and would be problematic in some respects, as they would specifically refer to registered European lawyers and registered foreign lawyers, rather than just including them under qualified individuals in the bill. They would provide less future proofing to implement the legal structures in the bill. Amendments 124 and 125 delete sections 44(1)(e) from the bill, which sets out that practice rules are to include rules about the making and handling of any complaint of an authorised legal business. I consider that under the provisions which allow the Scottish Legal Complaints Commission to make minimum standards for complaints handling in consultation with the profession and the Lord President, that it is important that section 44(1)(e) remains as a mechanism to apply those standards. After careful consideration of Amendments 123 and 126, I am content to support these amendments. I therefore ask Mr O'Kane not to press his amendments in this group, with the exception of Amendments 123 and 126, and if any of the other members are pressed. Yes, of course.
Martin Whitfield.
I'm very grateful to the Minister for taking the intervention, particularly at the perenation of her discussion. Does she have confidence that amending the explanatory memorandum post the passing of the bill into an Act carries enough guarantee that the interpretation that will be placed on it, both by those regulators but indeed perhaps the courts, is sufficiently strong enough for it to reflect the change in view that I think the government has taken to ensure that we encompass correctly overseas registered lawyers?
Minister.
Yes, I do, and I think even adopting what the Law Society have given in their text, put in the explanatory notes, will ensure that that will be done. And just with the amendments that Paul O'Kane might bring forward, there will be unintended consequences, which I said in my speech earlier on. So I therefore ask Mr Kane not to press his amendments in this group, with the exception of Amendments 123 and 126. And if any other amendments are pressed, I would urge members to oppose Mr O'Kane's amendments, and I ask members to support my Amendment number 1 and Mr O'Kane's Amendments 123 and 126.
Thank you. Minister, can I just check, Ms White, are you wishing to contribute?
My questions have been asked.
Thank you, Ms White. In which case, I call on Paul O'Kane to wind up press or withdraw Amendment 117. Mr O'Kane.
Thank you very much, Presiding Officer. I would, in terms of what the Minister has said in relation to the Law Society's view and the exchange of letters which happened yesterday, the Minister mentions and has mentioned in her contribution a number of times unintended consequences. I have to say that in my discussions with the Law Society, they are not clear as to what those unintended consequences would be. They are concerned that they don't have clarity in terms of what the Minister refers to, and indeed they are keen to see what I have described, I think, as a belt and braces approach by putting this issue to the forefront and the face of the bill. Now, whilst I intend still to move forward in that regard, I do understand and respect what the Minister has said in terms of her amendment to the explanatory notes, and that she is willing to accept the Law Society's wording on that issue, which I do think will go some way in terms of trying to find the compromise that we are looking for. However, I do think what is clear is that, given the significant concerns that have been raised by the Law Society in their correspondence, I will press the amendment.
Thank you. The question is that Amendment 117 be agreed. Are we all agreed? No. Parliament's not agreed. There will be a division. As this is the first division of the stage, I suspend for 5 minutes.